part of that legislative procedure that you and I have discussed in the past too. Judge Scalia, yesterday's Wall Street Journal quotes Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit as saying the words fairness and justice are terms which have no content. I'm interested in your view. Is the word justice one that has content to you?
Oh, yes, I think, of course, I think it has a content. I'd be surprised if what Judge Posner meant was not simply that, at least at the margins, and it's usually at the margins that we're talking when we have litigation in front of us. People disagree as to what justice requires, but I believe it has content, and fairness has content.
I ask that only because it jumped out at me when I read that, knowing that the first line of the Constitution says, "We, the people of the United States, in order to form a more perfect union, establish justice," and so on.
He shouldn't have put it that way. Should have known better.
I suspect he probably feels that way today, too. Maybe the Wall Street Journal, as Judge Heflin said.
I'm sure he doesn't mean anything different either, Senator.
Judge Scalia, you've been an outspoken critic of the Freedom of Information Act, and you've written and spoken out against the 74 amendments to FOIA. At the time these amendments were passed, were you the Assistant Attorney General in the Office of the Legal Counsel?
Yes, I was.
Did you have an opportunity to review those amendments and recommend to President Ford whether he sign or veto those amendments?
Yes, I did.
And what was your advice to President Ford?
Is this public knowledge, Senator? I don't know. If it's not, I think I probably shouldn't disclose it unless the President wants me to. The President vetoed the amendments, and I think he set forth in his veto message what his principal concerns were. The major one was the requirement of the amendments that courts review de novo justifications for withholding on the basis of national security.
Is it saying, do you agree with that veto?
Come to the same question. Do I now?
Do you now agree with that veto?
I don't have any views on such matters now, Senator.
Did you agree with the veto at the time?
Senator, I have no compunction in answering at all, except the attorney-client relationship that I had with the.
Let me just ask, on your own personal legal opinion, did that veto comport with your own personal legal views of the Freedom of Information Act?
I think it comes to answering the same thing, and I really. I think I shouldn't, in deference to the attorney-client relationship that I had with it.
And I'm really not trying to find just
I've criticized those amendments, Senator. I think you have in front of you. I mean, I'm in print as having criticized those amendments. I might also add, however, that when I was chairman of the Administrative Conference of the United States, I testified before Congress in favor of proposed amendments to the Freedom of Information Act and in favor of proposed application of the Freedom of Information Act by the agencies that were in the direction of liberalizing some disclosures. So
But going to the 74 amendments, which you did write about and which you spoke out against,
yes,
the President then vetoed these amendments that you wrote about and spoke out against.
yes.
The Congress overwhelmingly overrode that veto.
I think they
because of that, would you have any difficulties in upholding the law as it's currently written?
No, none whatever, Senator. I've upheld it as it's currently written. And I'm not sure whether Congress simply overrode the veto or did they make one minor change before they overrode? No?
You vote up or down on the veto, Judge.
Okay.
We don't even get a chance for the the staff to go in and write a report.
But they could. That's right. I suppose that's right. They did override and not pass an amended bill.
When we discussed this, am I correct in in summarizing our conversation, that you said that the law, sensible or not, was clearly written, and that Freedom of Information Act cases which you have heard were never particularly difficult to resolve.
Oh, no, no, you must have misheard the latter. Some of the most, I can name a couple, some of the most complex cases I've had were FOIA cases. I think
Was that because of the facts or because of the law?
Both, but probably more often the law. Church of Scientology is one of the cases. I commend it to your attention as an incredibly complex opinion, both the panel opinion for 3 judges which I wrote and the in-bank court opinion which I wrote. And it's one of the most complex pieces of statutory interpretation that I had to set my hand to.
Do you find the Freedom of Information Act a clear act, irrespective of how you may have felt about it, and felt about the 74 amendments? Do you find it a clearly written act?
No, I would not. I would. If you asked me for an example of a vague statute, the Freedom of Information Act is not what I would immediately pick out. There are some areas where, after I guess a couple of decades of experience now, the statute could be made more precise. But if you ask me for a vague statute, that is not what I would mention as a prototype.
FOIA was enacted before I was here, so I have no pride of authorship one way or the other, because I'm not involved in it, but I do want to, it is an act that keeps coming back to us, and it's one that I've been very involved with since, and and do I understand that the act is, at least as acts go, a clear act? It is not a vague act.
I don't know what you mean by almost any piece of legislation. You can say that there are some areas that could be more specific. There are certainly some portions of FOIA that are like that. How specific Congress wants to be, is always a question in every statute. The problem with FOIA, Senator, is that unlike most statutes that Congress passes, it isn't addressed to a single agency, so, addressed to OSHA or to the Food and Drug Administration, so that even if it has a certain amount of vagueness, you're going to get a standardized interpretation by one single agency. The problem with FOIA is that it goes out there to every agency in the executive branch. So to the extent there's any vagueness at all in FOIA, that vagueness is going to have to be resolved at the district court level, because each agency might resolve the vagueness somewhat differently. Now, the Justice Department tries to, at least it used to in the days when I was there, try to get the agencies to come up with a uniform interpretation, but I think you can say that there's special need for precision when you have a statute that is a cross-cutting statute.
But there are a lot of acts that go that way. A lot of your employment acts and employment practices and so on are the same way.
I think that's so, although most of those are in much more detail than FOIA. I have no particular, I don't know what you're driving at. I guess what I'm saying. I suspect that there's some legislative proposals to amend it.
No, I just said,
I really have no
I'm concerned about the FOIA. You will be having FOIA cases, I'm sure, before the Supreme Court. Aware of your opposition in 74, and I want to know if that, in your mind, does that opposition create a problem for you in hearing FOIA cases now?
No, Senator, I was asked that question earlier, I think, when you were out of the room, and one of the things I said then, and I stand by it now, is that to the extent that I've made significant law in the FOIA field, I've had a lot of FOIA cases, I don't know what the score is, but to the extent I've made significant law, I think it is in the direction of broadening access rather than restricting access, which...
I'll go back to the transcript of your earlier answer. One of the problems that happens to us in all these things, we have 4 or 5 matters going on at once around the corner of the Appropriations Committee meeting, on which I also serve.
I understand that.
Handling matters there. Judge Scalia, do you recall, well, I recall it was just last year, the Western Union Telegraph Company versus FCC. There was a case involving AT&T and MCI.
Yes, I do, Senator.
And were you asked to recuse yourself in that case by any of the parties or litigants?
No, I was not, Senator.
In '82, you were not on the bench. You'd received a consulting fee from AT&T in an antitrust case between them and MCI. Did you feel that that was close enough in time or significant enough in involvement to call upon yourself to recuse yourself?
No, I didn't, Senator. I had not been counsel for AT&T. I mean, I had not had a long-standing attorney-client relationship with them or anything like that. I had simply done a one-shot job of consulting with them, I guess 2 years or so before I went on the bench, and the compensation may have been just the very year that I went on the bench. And once before, I had taught a seminar for some of their executives about communications law one afternoon. That was the only association I had had with them. It seemed to me that 2 or 3 years disqualification from AT&T matters would be more than enough to eliminate any appearance of impropriety. In all of these cases, of course, it's not just a matter of an interest on just one side and no interest on the other side. It's a cost to the court when I have to disqualify myself, of course, and it's unfair to the litigants. If there's no proper reason for disqualification, they're entitled to get a shot at the full bench of judges and not just at the full bench minus 1 or 2. So I decided that I would recuse myself for a period of 3 years. I informed the clerk of the court that I would not participate in any AT&T matters. That means that I'm, as a practical matter, disqualified from all common carrier litigation, which is a good chunk of D.C. Circuit business. After 3 years, I instructed the clerk to put me back in the pool for AT&T cases.
You did not agree with Mr. Friedman, the former dean of Hofstra Law School, who disagreed with your refusal?
No, not at all, Senator. And I don't know anybody else that agrees with him either. I've had nobody that has told me they thought that 3 years' worth of disqualification for that kind of prior financial connection with AT&T wouldn't be more than enough.
In another case, you wrote the decision in Block versus Meese, which dealt with the labeling of foreign films as propaganda. One of the 3 films involved in let's see, one was an Academy Award-winning film on nuclear war, 2 dealt with acid rain. In the decisions, I said labeled them as propaganda. Now, next term, as I understand, the Supreme Court will hear a California case, not a D.C. case, but a California case dealing with the same issue and, in fact, the same films. Is that one that you would feel that you should recuse yourself on?
I've been thinking about that, Senator. What do you think? I think it's a close one. It's not the same case. It's just the same issue of law, but the case is really.
I've not given the sense of the question of recusal much of a mind. But I don't think that I'm on President Reagan's short list for judicial nomination.
No,
even though he'd have a chance to get both an Irishman and an Italian at the same time. But
all I can say, Senator, is I'm thinking very hard about disqualifying myself from it. They are the same films, not the same parties in the litigation, but it are the same films, not just the same issue, but the very same films involved. I think I will probably disqualify myself, recuse myself.
I might say only because
I wouldn't want to argue to me in that case.
I understand. Only because you had asked me the question on it. I would reach the conclusion the one should recuse himself.
In for a nickel, in for a dime. I may as well. Yes, I will recuse myself, Senator. I feel uncertain enough about it that I don't think I ought to go near it.
So I look at it this way, it'll probably get you out of having to watch the films again.
I never watched the films. That was not part of litigation.
Back, back in an area, and I would like to go into, you served under Attorney General Leahy, who conducted a pretty extensive review of the domestic security program at the FBI and the Justice Department. He ultimately issued guidelines as to the appropriate scope and conduct of domestic security investigations. They were revised by Attorney General Smith, but they're basically the same guidelines. The Leahy guidelines are basically what we use today.
I don't think so, Senator.
No?
No.
How do they differ today?
Well, I don't know the extent of the difference. All I know is that the intelligence community, so-called, did not like the Leahy guidelines at all, and that the Smith guidelines were thought to be more acceptable to them. I know there are differences. I don't know what they are.
Wearing another hat, I deal with those same intelligence agencies, and I don't see an awful lot of difference. That's why I was curious what you might.
I've been out of that field for a long time, except that I know that some of my former associates in the intelligence community dearly did not love the Leahy guidelines, and I think I thought that some of the impetus for the changes was from those people.
What was, did you work on the development of those guidelines?
I believe that Mary Lawton, who was my deputy at the Office of Legal Counsel, was the prime worker with the Bureau and the other intelligence agencies in developing the guidelines.
Who is still involved in that field?
I'm sure Mary has now gone on from the Office of Legal Counsel to, I think, a whole new post just dealing with intelligence matters.
Did you have any occasion during that time to consider whether Congress had the constitutional authority to legislate restrictions on the scope and conduct of such investigations?
Did I have any? I don't think I had any occasion to consider it, Senator, because I don't think there's any question that Congress does.
I'm sorry, I didn't hear that last.
I'm not aware that it was ever in question that Congress had authority to act in the field.
Was the FBI's COINTELPRO program underway when you joined the Justice Department? I'm having a little trouble recalling myself when it ended.
Oh, I'm sure it was all over by then, Senator.
Did you have any occasion on the Office of Legal Counsel to render opinion as to the scope or the authority or the legality of domestic security investigations generally that you recall?
Not that I recall, Senator. Not that I recall.
In the standard questionnaire, an area that I always find of interest, judges are asked is, quote, what actions in your professional and personal life evidence your concern for equal justice under the law? And you answered the question in part by referring to your work in support of legislation to overturn the doctrine of sovereign immunity. Can you describe the kind of work you did as assistant? Oh, I'm sorry, Mr. Chairman, I didn't realize the time was up.